First things first is thank you, IG Hendricks, for hosting a wonderful recognition ceremony for 4 of our former members that we've had. It was an excellent turnout, and welcome to all of our guests that we have here today. With that being said, we're going to go ahead and roll here through the minutes. The first one is the approval of the minutes from the previous meeting. Can I get a motion to approve the minutes?
Move.
All right, and second?
Second.
All right, it has been properly moved by Ms. Board Member Jackson over there and second by Dr. Ford that we approve the minutes. Now moving on to an update from the Inspector General.
Well, again, good evening. So you do have in front of you the monthly stats for August. If you have any questions, I'm available.
Oh, that's it?
Oh, yeah. I'm sorry. I'm sorry. Yeah, that's it. If anybody has any questions, please let me know, or if you have any questions towards the end.
Don't see any questions, so thank you, IG Hendricks. We appreciate you. Next up, we have Assistant Chief Conves coming to talk a little bit about recommendations and policy reviews from the Columbus Division of Police. Chief Conves.
Yeah, so I'm going to address some questions that the board posed to us. We got a list of questions, and I want to go over, maybe shed some light on the process, hopefully answer the questions that you all have. The first question was, can we explain the process that board recommendations, whether they're case-related or policy-related, go through in the chain of command once received? So the process is different for both. Any case-related recommendations, so if you have recommendations on a specific case, that's going to go to our Internal Affairs Bureau. At the conclusion of your, when you vote on it for a finding and it comes over, they're going to package, the administrative sergeant's going to package that with, all the evidence and things of that nature, and with the investigation, and going to send it out to the chain of command. The collective bargaining agreement kind of dictates how the chain of command review goes and how discipline goes. And so it's going to start at the lowest level, the immediate supervisor of the involved employee or employees, and they're going to review it and see, determine whether or not they agree or disagree with the findings. If they agree, they can just, write on their on the routing sheet, we agree, we concur. If there's a disagreement, they are required to write a summary and justify why they are disagreeing from a board finding. And that's no different if it's a board finding or if it's an internal investigation and the investigator has recommended, internal affairs says something sustained and they don't agree with it, or they say unfounded and the chain of command says, nope, that's sustained. They have to justify why that is. Also, if something is sustained, they should be making a discipline recommendation for that. And again, the contract, the collective bargaining agreement is going to govern that process. Generally, we must follow progressive discipline, which is going to start at the lowest level of documented constructive counseling. In critical cases where there's a critical misconduct or a more severe offense, such as an officer getting arrested off duty or things of that nature, the chief of police can approve deviation from that, and the chain of command would just recommend deviation from progressive discipline, and then the chief can determine whether that just goes up to a written reprimand or there's going to be departmental charges, potentially with a suspension or termination in that case. So that's kind of the process that case-related inquiries go. As far as policy recommendation that the board makes, those go to our Professional Standards Bureau. That bureau houses our accreditation unit and also our research and development unit. We have units that their sole purpose is making sure that we are able to maintain our accreditation, which is very important to us and I think very important to the community. We are under hundreds of best practices, that standards that the CALEA sets for us. And so it might appear on its face that a policy recommendation is so easy to implement. That's not the case for us. We must highly scrutinize those. We have to make sure that they are in line with our accreditation standards. Then it's going to go over to our research and development unit. They are going to do research and, they can conduct surveys across the nation of how other agencies are handling certain issues, or hey, they can put out a request, can you all send us a draft policy or any of your policies on this specific topic. So then we can look at how to best, is the recommendation within best practices that other agencies are doing or they've seen good success with. Once all of that happens, we also have to have a legal review to ensure that a lot of our policies are rooted in case law, and that's ever changing. So sometimes it might appear that a policy should be changed when in reality that policy is rooted in a case, and we must follow that. But there are times when the policy does need to be changed, and in those instances, what happens is if it goes through all those reviews and everyone's like, yeah, we could absolutely change that policy, no problem at all. What happens is it gets drafted by our research and development unit. It goes through concurrence. And what the concurrence is we have 2 levels of concurrence. We have general concurrence, which the draft policy is then sent to all of our commanders and all of our bureau managers. And they are going to each review it. They each have different they work in different parts of the police department. So they all have different priorities. They have different operations. So they're going to review that and they're going to provide feedback. Is there anything that we missed when we were developing that policy change that they're going to bring up maybe that says, hey, this isn't going to work for our bureau because we operate like this because of X, Y, or Z reason. And then maybe we have to tweak it a little bit. But they're going to provide in the concurrence process their recommendation and why. Hey, I like this, or no, I don't concur with this. Here's why. I would recommend changing the language to this, or sometimes it's just changing a word. One word can change a policy, and so sometimes we'll say, hey, I think the comma should be here, whatever the reason is. Then it goes back to research and development. They take all of those comments from our command staff, and then they implement any of those changes, or they write the reasons on the side, and then it goes to executive concurrence. And in executive concurrence, what happens is that goes to our deputy chiefs, our assistant chiefs. And so, again, same process. Everyone's able to review it, able to provide input on it. And then after that, it goes back to research and development to take any of those comments and implement those changes if they're appropriate. And then it goes to the chief of police for signature. And then it becomes part of the policy. Now, our policies are sent out 4 times a year. So we do them quarterly, and so if we have a policy change that's not exigent, we will wait until the next distribution, like September 30th is our next distribution, so we already have all those policy changes that are going to be going out. We are also required on a routine basis to review every single policy as a part of CALEA. That is, so we are constantly sending all of our policies through for concurrence to make sure, is there anything changed in the last 3 years that we might need to update a policy for? So they're all on a schedule of us reviewing those policy changes. There are times when we have a exigent or a very high priority policy change that needs to be made. Now that process I just talked about is lengthy for a specific reason. It's to make sure that when we change policy, it is the best that we can make it, right? But there are times when we have to put a temporary policy out, and we do have a mechanism in place. If something changes, a case comes down. Most recently, we had a case in which the city was in litigation over an officer-involved shooting, and it had to do with handcuffing individuals after there's a use of deadly force on somebody. And we saw a trend in the courts, and we thought, you know what, we're not going to wait for that case to be concluded. We think it's probably a best practice for us to change that policy and retrain the entire division, and we did that immediately. And we had a favorable outcome in that case, and so there are times when something is pressing and we will put a temporary policy out immediately until the next distribution. But those are few and far between. It just depends on the need and the exigency of it. So the second question was about the timeline for the review process to be completed and whether or not CPD has any internal benchmarks for that. That's a very hard question for me to answer because every case is so different. I talked about the review process, and there are times when the chain of command concurs with the board's recommendation. In those cases, they aren't doing extra analysis. They aren't having to write a lengthy response justifying a deviation from the board's recommendation or the Internal Affairs Bureau's recommendation. And so those typically fly right through. Those can be as quick as 3 days through the whole review process. So it varies. I took a list of the last, so we meet pretty regularly to go over when there's a difference between like what the chain of command has found and what the board has done to, regularly look at those cases and say, hey, what happened here? What was the reason for that? And so I looked at all of those cases before coming here today, and the longest one I think was 60 days for the review. The shortest was 2 days. So you can see the vast difference there and the length. But you got to remember, those were all cases where the chain of command and everyone in the chain of command had to write a response. So those are going to be longer than the normal, hey, we agree with the board. So that's on the longer end. And it's still, we find, is still the quickest part in the process, if you will, of those reviews. So I can't really say that there's no standard for us, and there can't be. There's a lot of factors that factor in. It depends on which level of employee is, what rank is the focus officer. If it's an officer, it has to go through the sergeant, the lieutenant, the commander, all the way up the chain. If it's a lieutenant that's the focus, it just has to go, it cuts it in half, right? It's just starting at the commander because that's the immediate supervisor. So it really depends on that. It depends on vacations, annual leave, training. Sometimes people are gone for extended periods of time for a week or two on training. And once you start getting into that with multiple levels of the chain of command, it can really get you up to 30 days, 60 days for that full review to take place there. So there was a question about the role that arbitration plays in the outcome of a case. Our grievance process is outlined in the collective bargaining agreement, and it consists of 5 steps. The first step is if somebody has a grievance, they're going to file it with the supervisor who basically made the decision that the employee feels it was adversely affected them or violated the contract. That's step 1. Step 2 is it goes up to the deputy chief for a second review if they're not happy with the grievance response on the first one. Then if they're not happy with that, with the grievance response from step 2, it goes to step 3, which is with the chief of police. The chief of police will hear that or her designee. And then step 4 is if they're not happy with that response, that grievance response, it's going to go over to the director of public safety for a hearing. And then if they're not happy there, then it goes to arbitration. We are under binding arbitration, so if something makes it to arbitration, we are bound by the arbitrator's decision. And so, yeah, that's kind of the role that it plays. And we must implement whatever the arbitrator says. So a lot of times in discipline cases or internal investigation cases, just cause is the big thing that is arbitrated. The union will say, hey, there wasn't just cause here. And, there's a lot of factors that factor into just cause. And, both sides will present their case. And then the arbitrator will decide whether or not there was just cause to discipline the officer at the level of discipline that was given to the officer, and either deny the grievance and say, yes, the management had the right to, or properly discipline the employee or take an adverse action against the employee, or no, and here's what you must do. If it's termination, we're gonna reinstate the employee. They might put other parameters in place, like we're gonna order you to reinstate the employee, but that employee does not get back pay. Or, I'm gonna bump it down from a 240-hour suspension to an 180-hour suspension. They can craft whatever they want, the arbitrator, and we are bound by that and must then implement that decision. We don't have a choice in that. So that's all been bargained and agreed upon in the collective bargaining agreement. The next question was, what factors impact whether the chain of command agrees or disagrees with a finding by the IG or recommendation from the board? There are a lot of issues that go, or a lot of reasons that factor in. A lot of it's going to be based on just cause. And so when we are reviewing the completed investigations, we are bound by the 4 corners of that investigation. It also asked another question, whether or not the chain of command does an independent investigation. There's no reinvestigation that can occur. There have been times when the chain of command has said, I think there is misconduct here, but I need a few more questions asked, and has asked, for further investigation. And then that is up to the Inspector General's office whether or not they're going to do that, or Internal Affairs Bureau. It does happen in both cases. And so in those cases, sometimes, they will reinvestigate or ask additional questions. Sometimes they don't, and then we're bound by the 4 corners of that. Is there enough in here? Were all the witnesses interviewed? Were the focus officers all interviewed? So looking back, and again, we work through all these issues. There's going to be bumps in the road on investigations. Sometimes the investigations are gray. Policies are gray. I wish that every policy could be black and white, but sometimes it's not. And we see that come out, and that might be where there's a difference in, how somebody interpreted a descriptive word in a policy or in a allegation, but we also see sometimes the wording of allegations is extremely important. And that is going to kind of dictate what the finding can be. And if it's worded in certain ways, that automatically removes potential findings. For instance, when the allegation states the officer used excessive force, that can never be exonerated, because excessive force will never have occurred but been within policy. Excessive force is never within policy. Whereas the allegation wording should be, the complaint is that the officer used force. So then when it's investigated, if it was excessive, that would be a sustained violation of our policy on excessive force, or if it was within policy, it would be exonerated there, or it could be unfounded. If the officer didn't use force, it could be unfounded if it's on video. So the wording of the allegations is vital to making sure that appropriate recommendations can be made as far as a finding goes. Compound allegations are problematic as well. If the allegation states that an officer said X and Y to a suspect, and both would be a violation of policy if they occurred, but the officer actually on video did say X but did not say Y. Therefore, the allegation can't be sustained because part of that allegation is not true. It was disproven. So those should be separated. Allegation 1 should say officer said X, and then allegation 2 should say officer said Y. So that way, if the officer did say X, that can be sustained, and then if officer didn't say Y, that can be unfounded. There. So compound allegations are very problematic. Using descriptive words in allegations are problematic. A lot of times descriptive words are hard. They're gray. They can be interpreted differently from one person to another. You all might even disagree on the board of whether or not something is rude, something is not rude. I'm sure there's a lot of discussion on those cases. A lot of times it's not black and white. As far as just cause goes, one of the elements requires that a thorough investigation be completed. So with that comes an expectation that all witnesses will be interviewed. Sometimes if there's potential or it appears in an investigation that there was evidence somewhere, did the investigator go and actually try to collect that evidence, go to wherever this occurred, or maybe somebody said that they had video. Did they try to go get that, collect that evidence? We want that to know yes or no something did or did not occur. That goes into a complete investigation there. So there's also times where the officer's conduct is permissible under case law. And so, there's times when that, they've come out sustained, but we get regular legal updates from our legal advisor, and we're very good about updating our officers on updates in case law. And sometimes the officers, are following the most hot off the press case law. And so the chain of command recognizes that and is able to cite the case and say, yes, they're permitted to do this. And then there's been other times where it's just the investigator's opinion and it's not rooted in policy. There's times when policy has the wrong section of policy has been used, and I'll give you an example. We had a case that we reviewed in which an officer was pacing a motor vehicle in a cruiser. And pacing is allowed, it's permitted. The officers are able to do speed enforcement via pacing.
For our viewers who may not know what pacing is, can you describe that?
Sure, yeah. So pacing is when the officer is driving in a cruiser and matches the speed of a potential vehicle that is speeding to determine what the speed of that vehicle is. And so the Supreme Court has it's a well-worn path of that is permissible. Our officers do that very regularly. And so as part of that, we had an officer ended up pulling up, match the speed of the vehicle that was breaking the law, and shine the spotlight quickly on the person to say, hey, stop breaking the law. I see you, slow down. That's permissible. The officer isn't required to make a traffic stop. Sometimes officers would do that when they are on their way to an important meeting and they can't make a traffic stop, or there's a whole number of offenses. Sometimes if they have a prisoner in the background, they might just shine the light real quick, hey, slow down. Well, the policy that was cited in that case was for traffic stops, and it talked about the high beam use, the headlight use, not the side. I get that it's bright, but so are all the overhead lights. We have takedown lights that are I would argue brighter than headlights, and so that was utilized. The traffic stop training supplement was utilized when no traffic stop had occurred. So therefore, that would be an improper use of that because the officer was not engaged in a traffic stop on that. So it would be no different than citing. You have a detective where somebody has cited a rule violation for a patrol standard operating procedure. Well, that detective doesn't work in patrol, so therefore those standard operating procedures do not apply to the detective. So we have general rules, the division directives, and rules of conduct that cover all employees, and then we have standard operating procedures that are specific to the specific job the officer is engaged in, and what unit they work in, and they're all different. You know, our vice operations are different than our our homicide operations, and our patrol operations are different than our aviation unit and whatnot. So the standard operating procedures operate as very unit-specific rules that the people in those units must follow. There. So a lot of different reasons. We meet and we talk about all of these issues, and we're able to button up issues whenever there are issues that arise. Does the next question was, does the chain of command notify the original complainant of the outcome of a case or the complaint following its review? And yes, we do. Prior to the creation of the Inspector General's office and the Civilian Police Review Board, we had that mechanism in place. When Internal Affairs would complete a citizen complaint, they would mail a letter stating what the finding was of the chain of command. There's an appeals process. That is no different. We still do that for cases that come out of the Inspector General's office because we think it's important that folks have a resolution to their complaints.
Thank you for that. You mentioned there's an appeals or there was an appeals process.
Yeah.
Then is that in place now as well?
Yeah, that hasn't changed. Our notification process has not changed.
Okay, and so what would that look like, for example?
So somebody can go in and ask for an extra review of it at a high level in the chain of command, and then it gets reviewed and to determine whether or not a finding should be changed.
Okay, that's helpful. Thank you.
Yeah. The next question was, how many officers have received formal discipline following the chain of command's review process? We don't track specifically just from the board, but we do track yearly every piece of discipline that is given to officers. Just for some context, in 2024, we issued 257 documented constructive counselings, 33 written reprimands, 5 suspensions, 1 demotion, and 2 terminations in 2024. So there is a lot of discipline that comes out. Luckily, you'll notice what those numbers show me is that with 257 DCCs, or documented constructive counseling, there's not nearly as many written reprimands, which means it's correcting the behavior. We're not seeing that progress. We're not seeing repeat behavior from there. And the number one thing when we issue discipline that we want it to do is to correct behavior. And so we don't see subsequent rule violations. And so I think the proof is in the numbers that generally does occur. Now, there are a couple cases where we do have to progress the discipline. We have a mechanism in place to progress the discipline, and that kind of goes into the next question. I'll explain that process. The next question was, do you keep a record of officers who have multiple complaints and or patterns of the same allegations repeatedly against them? If so, how does that factor into disciplinary actions for that officer? Prior investigations against that officer cannot factor into current investigations. We are bound by the 4 corners. Now, it can factor in if discipline has been issued out of prior. We can progress discipline. We progress that on a specific timetable that is outlined in the collective bargaining agreement. I'll give you an example. When a documented constructive counseling is given to an officer, for 9 months after the issuance of that piece of discipline, if the officer does something same or similar, and that within that 9 months that's outlined in the collective bargaining agreement, we can progress that then next to a written reprimand. Then they are bound by it for 3 years from the date of the incident that gave rise to the written reprimand. And then after that, if they do something same or similar, same with a rule violation in that 3 years, that gets progressed and it goes up to departmental charges. And then we start getting into suspensions. Suspensions are able to be held against the officer, used administratively for 4 years to progress discipline further for lengthier suspension up to and including termination there. So we do progress the discipline if there are same or similar violations of that. That's essentially how that works. We do.
Can I ask you a quick question? Sure. So you said that's for similar violations. Now, if we see different behaviors from let's say, the same officer, what does that look like then?
Sure. So if the violation is not the same or similar, and I'll give you an example. An officer, let's say, accidentally leaves a cell phone from a suspect on the trunk of the cruiser when they're searching them. That's something we see sometimes, and it falls off and breaks. And the officer's given a DCC for failing to care for an arrestee's property. And then they're late to work, 2 weeks later. Those are completely separate violations, and they would receive a documented constructive counseling for both of those. So it has to be, it's kind of bucket discipline, if you will. The conduct has to be in the same bucket to progress that discipline. And that is all outlined in the collective bargaining agreement there. Yeah. We also have a disciplinary tracking system. So you might wonder, well, how do you keep track of when discipline needs to be progressed? And all of our supervisors, when they go through the chain of command review process, they are required to check the discipline tracking system. So every piece of discipline is entered into that system. And so they can pull up the officer and say, okay, this officer has no prior discipline, so we're going to start at a DCC because it's a minor policy violation. Or they can say, oh, wow, this officer was late, 4 months ago and received a DCC, and now they're late again, so now it needs to be a written reprimand based on the discipline tracking system. So we have a system in place that keeps track of all that. Additionally, one of the factors in just cause is we have to make sure that discipline is handed out fairly. So similar rule violations for similar situated officers must result in the same level of discipline or similar discipline, absent mitigating factors or aggravating factors. So the discipline tracking system allows us, when we have critical misconduct, to determine, okay, an officer got arrested off duty for OVI or DUI. I'm going to get in here for a Rule of Conduct 101 violation. Okay, there's 20 entries, and this officer here in this case got an OVI and received a suspension. This officer got an OVI and received a suspension. So now I know I need to recommend deviation from aggressive discipline. We could discipline that supervisor reviewing if they come in with critical misconduct and it's clear in the discipline tracking system that all the comps support a suspension, and they come in and recommend a DCC for that. That would be an improper discipline recommendation, and we would expect them, to be in line with what's in the discipline tracking system to ensure we're handing it out in a fair manner, a fair and equitable manner. That's how that works. I will say that sometimes something might be sustained from the board and sustained by the chain of command, but it is the officer, their work record is phenomenal. It's the first time they've ever, broken that rule. We also have positive corrective action. So for really minor policy violations, we will sometimes issue positive corrective action to see if that corrects the behavior before issuing formal discipline to that officer. Again, we encourage our supervisors to utilize positive corrective action when appropriate for minor policy infractions. Yeah, go ahead.
Do you ever look at an officer, excuse me, who has a substantial number of complaints, but they are unfounded?
Yes, we do. That's where our EARS system, our employee action review system, comes into play. And what that is it's kind of our alert system, and we look at a whole bunch of different factors. We look at uses of force. We look at uses of mace. We look at injuries to prisoners. We look at citizen complaints. We look at uses of taser and higher levels of force, and we compare them across the entire division, and we pull out the officers that have the highest percentage. And all of those might have been unfounded or found within policy, but then we look for patterns. Is there something, could the officer, they've used force 4 times, and each time it was justified, but maybe they're not using enough de-escalation, or maybe they need to go to de-escalation training or communication training. And so we'll look for those patterns, and the committee is made up of people from all across the division, and sometimes when they make a referral, they'll write up the reasons. Hey, it looks like this officer is very quick to use mace on folks. So then they'll send it to the chain of command to develop a plan, and they're required to develop a plan to mitigate that and come up with how do we retrain this officer, how do we try to minimize their involvement in future uses of force if possible. So yes, we do have that. Injuries to prisoners, same thing. Citizen complaints, they're getting a lot of rude and discourteous complaints, but they're unfounded. Maybe they're not talking enough, or they need to use other communication techniques, and we can identify that, and they can get that through training. We might send them back to training. So yes, we do have that system in place that flags those various various things for us. Yeah. So again, the next question was, how does CPD identify systemic patterns of recurring issues across complaints, and what is the process for turning these findings into potential policy changes? Again, the chains of command are very aware of, if the same types of sustained complaints are coming out on officers or the same conduct is occurring, they're going to look at, is it something, do we need to get them a different piece of equipment to help them better, interact with the public? Is it training? Is there a gap in training where there are times when annually our training committee meets and they say, hey, we're seeing this trend. Let's try to do training on it to see if we can reduce that trend. The example I gave you earlier about the handcuffing of folks, that was a trend we saw where courts were not, were highly scrutinizing officers' action post use of deadly force. And so we had to look at that very quickly, and we looked at that and said, you know what? We do see a gap in training here, and we literally sent the entire division through. Every officer had to go back and be retrained on that. So yes, we do recognize that. We generally use our annual in-service training for that, but there are times when something is so critical where we will carve out a separate training day or, training 2 hours where we make them come out and retrain. Years ago, we saw a trend nationwide and within the courts about shooting at moving vehicles, when officers were shooting at moving vehicles. And so we implemented training scenarios where we drove a car at an officer and taught them to take evasive action before using deadly force, to try to get out of the way of that vehicle instead of just shooting at the vehicle. And we saw a dramatic reduction in that. We also changed policy as it referred to that. But that was a trend we saw. Sometimes it's not just within CPD. The trend is national or within the courts. And so we are going to always highly scrutinize those things.
So thank you for that. That's super helpful in terms of, as a kind of a concrete example. One of the questions that I have is just in terms of capacity and potential capacity constraints and the roles that boards like this can play in terms of thinking about the patterns and practices. Like, is capacity, I'm assuming the answer is always yes for a lot of these things, but how are there ways that we can think about as a board or working with the Department Inspector General, thinking collaboratively about addressing some of these patterns and practices, right? And so it's less just a reactive nature, but more so thinking about what are repeated patterns you're seeing. Do you work with independent universities or others to kind of identify these issues? Like, what is capacity and how do you handle those capacity constraints?
Sure. Yeah, we have collaborated pretty regularly over the last decade with educational institutions to come in and review. We've had independent reviews. Most recently, we had a external consultant come in and do a review of our use of force, not only just our policies, how they're investigated, how they're documented, are we tracking all that stuff? And, so yes, we do routinely have independent reviews of our policies. We always welcome eyes on our stuff. But again, CALIA also comes in and does the assessment, and they're going to focus and really dive into specific areas. One that most recently, was looked at was our ears that I mentioned, the early warning system. We take any recommendations that come out of these independent reports, and we always highly scrutinize, our practices, and are always open to, is there a better way to do it? We might not be able to think about the best way, but someone in the country has the best way to do it. And so that's why we stay in contact through our research and development unit about what are other people doing, across the nation, and should we be doing that here? And we also have folks that come to us where we are doing groundbreaking stuff and say, hey, how did you do that? And we are always willing to share our policies, with other folks. Sharing knowledge is very important among law enforcement agencies, and we do that pretty regularly. But we are always in contact with, various educational institutions to do research and all that stuff. We routinely engage in studies. Yeah. The next question was, what does progressive discipline look like in relation to sustained case allegations? So I think I've already hit on all that, but it's outlined in the collective bargaining agreement. It starts with a documented constructive counseling as the lowest level. If we're going to do formal discipline, sometimes positive corrective action will fix whatever it is, the rule violation. After that, it moves up to a written reprimand, and then it goes to a suspension, demotion, and termination, depending on, how we can progress it in the administrative use guidelines. How that works. The next question was, how are policy recommendations reviewed and addressed upon receipt from the board? I think I answered that in the very first question. Depends on what it is. If it's a policy, it goes through the Professional Standards Bureau, through the accreditation review and research and development and whatnot, and then the rest go through the chain of command there. Lastly, the Civilian Review Board, along with the Department of the Inspector General, recommends discipline in an extremely small percentage of cases that are filed with the Inspector General's office. The vast majority of our recommendations for discipline are rejected by the chain of command. Can you explain to us what the standard is? And this is where it came in. Is there an independent investigation that occurs by the chain of command? That is not the case. The chain of command, in fact, is prohibited from doing an independent investigation once it comes out from, whether it's IAB or it's the Inspector General's office. We do not have them do an independent investigation. They are bound by the four corners of the investigation. With that comes good and bad, right? If the investigation is thorough, it's complete, and it outlines a clear violation, absolutely they're gonna be able to sustain it. If there's things missing in here that's glaringly obvious, if the focus officer, for instance, wasn't interviewed because something was on body camera, well, that's going to violate just cause, and the chain of command is going to immediately recognize that and write a recommendation accordingly. So it varies on any of the factors that I provided of how those end. I think the vast majority of the complaints are coming out not sustained from the board. I think day in and day out, our folks are doing a good job of following the rules. We do know that sometimes they do break the rules, right? And we have sustained allegations coming out of the Inspector General's office and from the board. And anytime the chain of command sustains an allegation, it is met with, at a minimum, positive corrective action, but generally some level of discipline. Yeah. So I think that was. There's one more question about. I want to talk to you about chases. I think you guys had some questions about our pursuit policy, and specifically the GPS launchers. I know that it was mentioned in it. We are constantly looking at new technology, whether it's for pursuits, whether it's for computers, whether it's for new tools to put on the belt, whatever it is. Yes, we are always evaluating those. Our research and development unit did put out a nationwide request for folks, hey, who's using this technology and is it working? We had 14 major city agencies respond. Of those 14, only 5 of them were using that technology. And that technology came with very, very mixed reviews. In fact, one of the 5 agencies says they were discontinuing using that technology because it was not effective. Some others said it was not effective at speeds over 40 miles an hour. So we did not move forward with that because it probably is not good for ours. But I want to talk to you about pursuits. Yes, pursuits are very dangerous. We know that. CPD has one of the most restrictive pursuit policies in the state of Ohio, definitely in the central Ohio area. With that, there's very few reasons that we allow our officers to chase. Even when one of those reasons is met, the thing that governs every single chase is the preservation and the risk to life. And so we know that there is always a risk, that somebody's going to get injured if there's a crash, whether they're occupants of the vehicle, whether they're an innocent bystander, whether they're in another motor vehicle. So we have to weigh, do we need to apprehend this suspect? If we have a homicide suspect who's extremely violent and they're taking off, we have a very high need to apprehend that individual now. So they can't reoffend, they can't go out there and shoot somebody else or, cause further harm in the community. Whereas if we have maybe a robbery that's 5 days old, this wasn't fresh, and we know the identity of the individual driving, do we perhaps, find other ways to apprehend that person versus chasing them? Also, one turn can change a pursuit. I'll give you an example. We had a pursuit, I believe it was last football season, that was happening in Linden, and the vehicle made a right turn and started going towards a very populated area during a college football game. To us, when you have a bunch of folks in the street and we have a high-speed pursuit, the officers immediately made the determination that the risk to the life of the people that were down there outweighed the need to apprehend the suspect, and immediately terminated the pursuit and turned off of the route. So we're not just behind them anymore, we completely turn off of the route, because if they see us, they're gonna, even if we shut the lights off, they're gonna keep speeding, but we turn off of the route to try to get the speeds to slow down. We also have the helicopter at our disposal. So if the helicopter's out and we have a very reckless driver, we can parallel the individuals or just stay in the area, let the helicopter follow and say, let us know, okay, they're turning on this, okay, their car's coming to a stop, now they're getting out of the vehicle here, and then we can move in and make apprehensions. We also have we have pit maneuvers that we train every officer in. We do use pit maneuvers to terminate pursuits. We also have stop sticks. Those are like road spikes that we use to safely deflate the tires at a controlled, over about 90 seconds. It'll slowly let the air out to try to avoid a crash in that vehicle and make it so they can't, flee anymore. So we have a lot of tactics that we use to try to minimize the risk. But again, the number one thing we're looking at is the risk to life of both people in the vehicle, to our officers, because it's very dangerous for our officers as well, and then to people that are outside there. So I think that was all the questions that you guys gave us.
Yeah, this was very helpful. I would like to go back and just ask 2 additional questions, and I'm kind of putting you on the spot because I didn't send these in advance. But one was in a reference to a comment that you made about when there is an additional review, and sometimes the wording of the allegation is off, or it doesn't warrant a sustained, things like that. I was curious to know how often, or has there been any sort of training with the IG's office to perhaps provide some additional instruction in terms of what the wording should look like, or what are some of the things that you all look for when the reports come over, the investigation reports come over to your wheelhouse?
Yeah, thank you for that question. Yes, like I said, we meet pretty regularly, and generally, the purpose of the meeting is to scrutinize and go over why was there a disagreement between the chain of command and what the board had recommended, and how do we potentially make sure that there's synergy moving forward. And yes, we have talked at length about various wordings of allegations, talking about descriptive words in there, compound allegations, all of the ones that I brought up. Yes, we have provided that feedback to them and made them aware of it. I will say that the 2 supervisors over in the office are phenomenal, and they are in constant contact with internal affairs, where they will ask questions back and forth, bounce stuff off. So yes, I have made it clear that we have a very open line of communication, and we want everyone to be on the same page as far as that goes. Yeah.
Okay, thank you. And then the last question that I had was pertaining to the progressive discipline. You mentioned the various stages of them, and then you talked about suspension, perhaps termination and whatnot. Can you tell me what factors into determining how many hours someone would perhaps be suspended? Like what goes into those considerations?
Sure. There's a couple things. The biggest thing that plays in is what have similarly situated officers received for similar misconduct violations. So we have a lot of cases of, for say, out of policy uses of force. And when we have those cases, we're going to get in the discipline tracking system and say, okay, this officer used 1 strike that was it was out of policy, and then we'll look at things like, was the suspect handcuffed? Were they not handcuffed? What led up to it? Could de-escalation have been used? And we look for similar fact patterns in the discipline tracking system, and then we try to issue a similar suspension. Now, there's aggravating and mitigating circumstances that the contract requires us to take into consideration. Employee's work record. You can have an employee where, they have 3 sustained, complaints of rude and discourteous conduct, and they've received progressive discipline for that. And now we're on the 4th offense of that. We can amp up the suspension versus you have one really bad case of rude and discourteous where, an officer says something that was extremely inappropriate. We're going to start at a higher level of discipline. We're going to deviate progressive discipline, but they don't have the same work record with priors as the other officer. So we would come down and lower the level of discipline a little bit. So there's no discipline matrix for us, but really the same or similar situations are going to dictate kind of how we do that. And we look at, in every case, we do look at the officer's work record, but we also look at, was the conduct a mistake or was it intentional? And the contract allows us to amp up the discipline or give a higher level of discipline if the conduct was knowing, if the culpable mental state was knowing, they purposeful in their conduct and did something versus they made a mistake and they've made the same mistake several times and now they're at departmental charges and a suspension where it wasn't intentional. We're going to treat those differently based on whether it was intentional or not intentional. So a lot of different factors factor in. I wish it was clearer, but it's not. Again, we have a discipline grievance office, and what we do in these critical cases where we are going to deviate is we have them do a just cause review of the case. And then part of that just cause review is they're going to bring comps and show us, hey, here's 10 comps where 10 officers have engaged in the same type of behavior, and here's the different discipline recommendations, or also prior arbitration decisions we have to go off of. So if we have an incident where an officer does something, the exact same thing as an officer did 4 years ago, and that case got arbitrated, and the arbitrator said we could only give a 40-hour suspension for it, we got to give a 40-hour suspension. We can't go higher than that unless there's aggravating or mitigating circumstances. So there's a lot of factors that factor in. It's a pretty complex review.
Thank you. I think that covered all of the questions that we had listed here. Everybody good?
Well, I was wondering if you had any questions for our board.
I don't. Yeah.
Okay.
We work pretty regularly with them, so it's we get there is a flow of information for sure.
Yeah, excellent.
Well, thank you both for coming. We appreciate you. This was a lot of good and insightful information that you all provided. One of the things that we noticed is that during some of the meetings, a lot of these topics, they recurrently come up. And so to have you come in and clarify, that was very helpful. So thank you both. We appreciate you.
Yeah, thank you.
All right. So moving on, we have the review of pending cases. We have the investigation review of, there was a case we had from Committee 1, 24-1576, that I believe we sent it back or held off on making a determination on that case to this meeting. I don't believe we have any updates regarding that.
Am I able to say something?
Yes.
You guys held it because you wanted to see what the outcome of the other case was gonna be. Verbatim. I mean, there's another case pending for the officers, and that officer, you guys wanted to see
Okay.
what the outcome was gonna be for that case before you voted on this.
And I don't know if we know what that outcome is
I mean, you guys are supposed to review that case this.
today. Okay. And so now we have the review of the August assigned cases. So we have Committee 1 review. And I believe we might need to postpone Committee 1's to the next meeting, actually. So we'll go ahead with Committee number 2.
I'm ready. The first case is 2024-1129, and this was a complaint. The DIG received notification from Franklin County Court of Common Pleas, juvenile branch, alleging excessive force by a CPD officer. The information alleged, number one, on July 29th, a 15-year-old juvenile male was struck by a CPD vehicle when he fled from an officer who was in pursuit. The information reported he was hit by the vehicle on his left side, which knocked him into the fence, where he sustained injury to his right knee, close quotes. On August 1, 2024, the DIG made contact with the mother of the juvenile subject, who said she was advised of the incident and wanted to pursue a complaint against the officer who struck her son with the police vehicle. On August 5th, the DIG placed the case on administrative hold and forwarded the allegation to Internal Affairs to disseminate to the appropriate section for investigation of potential criminal misconduct. On September 24th, the DIG received notification that the focus officer was on medical leave. Then in January of 2025, the DIG received an update from IAB advising that the criminal investigation was completed and there was no probable cause to support the filing of a criminal charge. Additionally, IAB advised that the investigation be changed from a criminal status to an administrative status and returned to the DIG for administrative review. The criminal investigation concluded, however, that the officer was still on medical leave, so the case remained on hold. Finally, on May 16, 2025, the DIG was advised that the officer returned to work, and subsequently, the case was removed from hold on that date. Then the DIG finally started its investigation. It consisted of administrative review of the documents received from IAB, a review of information received from the Franklin County Juvenile Branch, interviews with the complainant and her juvenile son, interviews with the juvenile witness and his mother, interviews with the focus and witness officer, a review of all the BWC available, review of photos retrieved by the DIG of the scene at the scene of the incident, review of information from ECC, and a review of applicable policy. Pertaining to the allegation 1, the CPD found no evidence of criminality to substantiate any of the complainant's allegations against the officer, and the DIG concurs with CPD's findings. Furthermore, the investigation found no evidence to substantiate the allegation that the officer struck the juvenile male with the police vehicle. Therefore, it is recommended that this allegation against this officer be closed as unfounded. So this particular case, our committee reviewed, and I went to watch the BWC because it was kind of hard to picture. Because in this particular case, the officer used his vehicle to turn and to keep the juvenile from escaping the scene. Now, the juvenile in this case indicated that the police vehicle, in quotes, on his left side knocked him in the fence where he sustained injury to his right knee. We looked at this, at the BWC here, and the vehicle never made contact with the juvenile. It did not touch his right knee. It is crystal clear on that BWC that the vehicle never made contact with the knee. So we, as a committee, concurred with the findings of the Inspector General in this particular case. However, we were disturbed as a committee as to how the vehicle was used by this particular officer to follow this juvenile. And it was a very complicated case because there had been a prior shooting the night before, the day before. The juvenile did have a firearm that he threw into the grass. The firearm was recovered. At the time of the chase, however, he did not have the firearm because that particular officer did view that he had thrown the firearm away, or excuse me, thrown it into the grass. But there was something about the officer, and he made his, he did not do what the allegation, I want to stress that, what he is alleged to have done. He followed policy and procedure, and, but we were, the fact that he didn't have his body cam on because he was in the vehicle, and he never did get out of the police vehicle, but he did have interaction with the young man because he did speak with him out of the out of the window, but then the young man started running, and that's where he started following him with the vehicle. So suffice it to say that our committee was just a little bit disturbed by the fact that an automobile was used to chase this young man. We thought that maybe the officer could have, he knew who the young man was because there were other people there that maybe not to use a vehicle, but maybe to park the vehicle and to chase him. He did have another officer with him, and not to use the vehicle as an instrument of, as he used it. But that's it. Any questions? Case number 2, 2025-0245. This was a complaint alleging that, number 1, the officer searched his vehicle for no reason, and number 2, impounded his vehicle for no reason. The DIG's investigation consisted of CAD, BWC, applicable policies, Franklin County Muni Court records, and a telephone interview with the complainant, and an in-person interview with the officer. With regard to allegation 1, the officer searched the complainant's vehicle for no reason. The investigation found that the officers were within CPD policy. It is recommended that the second allegation against the officers be closed with a finding of exoneration as to impounding the vehicle for no reason. Let's see here. So that's, we reviewed it, and we found that we do agree with the findings of the Inspector General. Case number 3, 2025-0310. This was a misconduct by CPD. The allegation is that the officers have been harassing him by waiting at his residence and targeting to pull him over. The investigation consisted of CAD review, BWC review, CPD policy and procedure review. The investigation found no evidence to substantiate the complainant's allegation that CPD officers have been harassing him by waiting at his residence and targeting him to pull him over. The investigation found that the complainant has been stopped for repeated traffic violations by different CPD officers. The BWC footage showed that CPD officers did not know who the complainant was when they stopped him and had trouble identifying him. Therefore, the DIG recommends a finding of unfounded. We did review this, and we do agree with the finding of the Inspector General. 2025-0312. This was an allegation of misconduct. The complaint stemmed from an incident where officers were dispatched to a person with a gun. The complainant alleged that the officer's actions of shooting her dog was misconduct. The DIG's investigation consisted of an interview of the complainant, review of the investigative packet of a dog shooting, a review of an interview of the focus officer, review of interview of 2 witness officers, review of BWC footage, review of CAD from the incident, and CPD policy and procedure. The investigation found that the complainant advised the officer she had just arrived home and discovered her home had been struck by several gunshots. The officers advised her they needed to search the home to find any potential injured victims inside. The complainant agreed to allow the officers to search the home. The officers could hear loud barking from inside the home and advised the complainant to take control of her dogs before they entered the home. The complainant agreed but lost control of one of the dogs. The dog ran from the back door directly at the focus officer. The focus officer attempted to back up, but the canine jumped and lunged at him. The focus officer fired his division firearm in a downward direction 5 times, striking the canine. CPD concluded the officer's use of his firearm on the complainant's dog was intentional and not in violation of policy. The investigation found the complainant's dog was an imminent threat to the officer's safety, and the use of the firearm on the dog was within policy. The DIG concurs with CPD's findings and therefore recommends that this allegation be closed with a finding of exonerated. We did review this case, and we do agree with the Inspector General that the focus officer was in imminent danger of serious physical harm. The BWC also shows the complainant apologizing to the focus officer and giving him a hug. So the next case, 2025-0330. This is an allegation of misconduct and excessive use of force by CPD officer. The complainant said that on April 23rd, 2025, he and his partner were having a domestic dispute when officers were called to his residence for assistance. The complainant alleged, 1, an officer snatched him by the arm from his front door. 2, an officer bent his thumb further backward after he complained about the officer bending it backwards. 3, an officer used his index finger and jabbed his rib cage. And 4, an officer used profanity and said, shut the fuck up, and I didn't tell you to fucking get in yet. The Columbus's DIG's investigation consisted of an interview with the complainant, interviews with the focus officers and witness officers, a review of the CAD report, a review of BWC footage, review of ECC materials, and a review of policy and procedure. Pertaining to allegation 1, the investigation found no evidence to substantiate the complainant's allegation. The officer warned the complainant that he would be detained if he continued to interrupt and impede the investigation. The complainant continued, and the officer grabbed the complainant by the left arm and detained him, but he did not snatch him by the arm from his front door as alleged. Therefore, it is recommended that this be closed as unfounded. Number 2 allegation, the investigation found no evidence to substantiate this allegation. The investigation found the officer guided the complainant to the police vehicle to be detained, and the complainant stated the officer was hurting his hand, but did not complain further that he was being hurt. As the complainant alleged, the thumb was bent further back after he'd complained, and no evidence was found to support this. It is recommended that this be closed as unfounded. As to number 3, the investigation found no evidence to substantiate the complainant's allegation. The officer's hand was placed flat on the complainant's back to control his movements while he was being escorted to the vehicle. Therefore, it is recommended that this be closed as unfounded. And number 4, the investigation found no evidence that substantiated the complainant's allegation or that any similar language was used. Therefore, it is recommended that this be closed as unfounded. We did review this case, and we concur with the findings of the Inspector General. Case number 2025-0342, this was excessive use of force allegation. Let's see. The investigation consisted of CAD, BWC, review of policy and procedure, and review of Muni Court materials. A telephone interview also of the complainant, and an in-person interview of the focus officer. With regard to this allegation that the officer used excessive force, the DIG's investigation found that the actions of the officer were within policy and procedure. Therefore, it is recommended that this be closed as unfounded. We reviewed this and found it all to be within policy and procedure. The next case is 2025-0344. This was a complaint of misconduct by CPD officer. The complaint stemmed from an interaction between the complainant and the officer on April 27th. The complainant was in his vehicle and exited a gas station after he completed refueling his vehicle. The complainant pulled out from the gas station exit to re-enter traffic and alleged that the CPD officer came up very quickly on his vehicle rear out of nowhere, and he had to maneuver to the adjacent lane to avoid a rear-end collision. When the officer pulled up beside the complainant alleged, 1, the officer used profanity several times toward him and his passenger, and number 2, the officer was speeding. The investigation consisted of interview of the complainant, interview of the passenger, review of activity log, interview of focus officer, review of policy and procedure. With regard to allegation number 1, the investigation revealed the officer did pull up beside the complainant and did use profanity toward the complainant and his passenger. The officer's actions were not within division policy. It is recommended that this allegation be closed as sustained. With regard to allegation number 2, the investigation revealed at no point did the officer speed, so this allegation is unfounded. Throughout the course of the investigation, it was revealed that the officer did have an interaction with the complainant, and he did not have his BWC on during this interaction. It is not within division policy, so it is recommended that the IG allegation be closed as sustained. So we did review this case, and we do agree with the finding of the Inspector General, and we also agree with the DIG allegation that the officer was in violation because he did not turn on his BWC. The next one is case number 2025-0351. This is a misconduct allegation. The complainant, on April 29th, 2025, between 12 and 1 a.m., he and his friend were at Westone Park Shelter House, quietly enjoying their evening when an officer arrived on a suspicious individual call. The complainant alleged, 1, the officer was rude when he informed him and his friend that they needed to extinguish the fire and leave the premises. Number 2, he interrogated his friend after he checked the VIN number for his friend's vehicle and found the license tags did not return to his vehicle. And 3, accused him and his friend of stealing the vehicle. The investigation consisted of CAD report, BWC footage review, review of ECC materials, and the review of policy and procedures. Pertaining to allegation 1, there is no evidence that the officer was rude when he informed the complainant and his friend that they needed to extinguish the fire and leave the premises. Therefore, this is closed as unfounded. Number 2, there is no evidence that the officer interrogated the complainant's friend. Therefore, it is recommended that this be closed as unfounded. Pertaining to allegation number 3, the investigation found no evidence that the officer accused the complainant and his friend of stealing the vehicle. So this is recommended that this be closed as unfounded, and none of this was on the BWC. So we reviewed this, and we agree with the findings of the Inspector General. The next case, 2025-0372. Excuse me. This is a misconduct allegation. The allegation is that, 1, an officer illegally searched him and an officer illegally detained him. The investigation consisted of CAD chronology, review of BWC, review of CBD policy and procedure. With regard to allegation 1, the investigation found the original call for service on this incident was a person with a gun. When the complainant refused to depart private property or provide identification, he was placed in handcuffs and a pat-down for weapons was conducted. Officers had evidence of a crime being committed and reasonable suspicion that there was a weapon present. There is no evidence to substantiate the allegation that the complainant was illegally searched. Therefore, it is recommended that this be closed as unfounded. With regard to allegation number 2, the investigation found the complainant was on private property after the hours of closure. The security firm for the property directed the complainant to depart. He would not. CPD was called, arrived, ordered the complainant off the property, and when the complainant failed to provide identification, the complainant was placed on handcuffs. CPD policy authorizes officers to detain or arrest for both of these violations. So therefore, it is recommended that this allegation be closed with a finding of unfounded. Our committee did review, and the officers here did follow policy and procedure. Everything was within, well, everything was proper, and we agree with the finding of the Inspector General. Next case, 2025-0390. Let's see. The complainant said that this incident occurred on May 14th, 2025 at 2:30 p.m. in the Aldi parking lot. The complainant said she mistakenly turned onto the road that was marked as closed when the officer pulled in behind her, blocking her vehicle. She alleged that there are two allegations. She alleged that the officer approached her vehicle and immediately began yelling at her. And when she attempted to respond, the officer continued to yell and demand her license and registration. She asked the officer if he wanted her to answer his questions, and the officer rudely responded, "You can answer them after I give you a ticket." The investigation consisted of an interview of the complainant, BWC footage review, review of Franklin County Muni records, review of ECC materials, and CBD policies. Pertaining to allegation 1, the investigation found no evidence to substantiate the complainant's allegation that the officer yelled at the complainant and demanded her license and registration. It is recommended that this be closed as unfounded. Pertaining to allegation number 2, no evidence that the officer responded rudely. You can answer that after I give you a ticket. It is recommended that this be closed as unfounded. We reviewed this and we agree with the Inspector General. 2025-0401. This is an allegation that, number 1, the officers falsely arrested the complainant, and 2, were being dismissive and not letting him explain anything. This was a review of CAD materials, all of the BWC footage, and CBD policy. The investigation found no evidence to substantiate the complainant's allegations of misconduct. Officers followed standard operation procedures for the enforcement of a civil protection order when they arrested the complainant. The complainant admitted to violating the protective order. At no point during the officers' interactions were they dismissive, and they did not, they did listen to what he had to say. Therefore, the recommendation here is a finding of unfounded as to both allegations. We reviewed and we agree with the finding of the Inspector General. Okay. The next one is 2025-0409. This was a complainant misconduct. The complainant alleged that an interrogation investigation was conducted by CPD regarding an incident that occurred at Mog Park on May 7th. The complainant alleged that she was interrogated by CPD in an unlawful manner through them psychologically intimidating her and coercing her, and 2, an unlawful search and seizure conducted, and 3, her civil rights were violated. The investigation consisted of CAD data, a review of answers by the complainant to a questionnaire composed by the Columbus DIG, and attempts to conduct, a review of answers by the complainant to a questionnaire composed by the DIG, and attempts to conduct an in-person interview with the complainant. Many generalities were made in the complaint letter received by the complainant's representative, and the necessary information needed to investigate the allegations were not in the answered questionnaire received by the complainant. Without speaking with the complainant, the DIG did not have sufficient information to identify the alleged officers or any specific details involving the incident to conduct a thorough investigation into the allegation. Pertaining to allegation 1, the Columbus DID made attempts here to interview the complainant, but received no responses. With no interview of the complainant completed, the DIG had insufficient information to determine how the complainant was interrogated in an unlawful manner through psychological intimidation and coercion as alleged. Therefore, it is recommended that this allegation be closed with an administrative closure. Pertaining to allegation number 2, the DIG made attempts to interview the complainant, but received no response. With no interview of the complainant completed, the DIG had insufficient information to determine if an unlawful search and seizure occurred. Therefore, it is recommended that the allegation be closed in this administrative closure. And for 3, the DIG made attempts to interview the complainant with no response. With no interview, the DIG also was unable to determine if civil rights were violated. So there was an administrative closure. This complaint came through email, and the complaint was written and signed by the representative of a complainant, and there was no way to get to the complainant because they would never answer the DIG's attempts, and that's why the administrative closure. And we concurred with the Inspector General that they did everything they could and were unable to get in touch with her. The next, 2025-0438. This was an allegation of misconduct. The complainant alleged that the officers approached her vehicle occupied by herself and her children with drawn weapons. The investigation consisted of CAD, review of cruiser video footage, review of all the BWC footage, and CPD policy procedure review. With regard to the allegation, the investigation found the officers did approach the complainant's vehicle, which was occupied by herself and her children with weapons drawn. The officers received a call for service involving a wanted felon with a firearm and the description of the vehicle with a license plate to the suspect, with license plate the suspect had gotten into. The officer's response and actions taken in this incident were consistent with CPD policy for a high-risk traffic stop. Therefore, it is recommended that this allegation be closed with a finding of exonerated. We did review and we agree with the finding of the Inspector General. The next one is 2025-0439. This was an allegation of, number one, harassing, the complainant alleged that, number one, they were harassed by the officer stopping him when he walked down the street. Two, issued the complainant a citation for no reason. And further, the complainant indicated, those were the two complaints. Then the DIG has an allegation that the officer failed to activate his BWC. So the DIG's investigation consisted of interview of the focus officer, CAD review, and review of BWC footage and CPD policy and procedure. The investigation found no evidence to substantiate the allegations, the complainant's allegation that a CPD officer harassed him when he walked down the street or issued him a citation for no reason. The complainant was stopped for committing a crime and was issued a citation. The complainant had not been stopped at any other time by this officer, and the DIG found no pattern for harassing behavior. Therefore, the DIG recommends a finding of unfounded. With regard to the DIG's allegation, the DIG became aware that the CPD officer failed to activate his BWC when he had an interaction with a citizen. Thus, the CPD policy states sworn personnel shall activate any time a citizen contact is likely to occur. This allegation is sustained. We did review and we do agree. Let's see. Okay, so we do agree with the finding of the Inspector General in this case. And also, we concur with the DIG's allegation that the officer did not have his BWC on during this encounter. The next one, 2025-0445. This was an allegation for excessive use of force. The complainant alleged officers used excessive force on her son and nephew during a traffic stop by slamming them to the ground. The evidence reviewed was an interview with the complainant's son, a review of CAD, an interview with the complainant, a review of BWC footage, review of CPD policies. With regard to this allegation, the investigation found the complainant's son and the nephew were in the vehicle subjected to a traffic stop. Both the son and the nephew ran from the vehicle. The son was found in front of a house and was directed to lay on his stomach on the ground. The son sat down on the steps to the house, and the officers took the son by the arms and placed him on the ground on his stomach. The nephew was found lying behind an air conditioning unit behind the house by a Franklin County Sheriff's deputy and ordered out. The deputy took the nephew by the arm, placed him on the ground on his stomach, and the CPD officer assisted in handcuffing the nephew. CPD policy directs officers shall not use more force than is reasonable in an incident. Neither the son nor the nephew were slammed to the ground. Specifically, they were taken by the arms, lowered to the ground into a prone position for handcuffing. Therefore, it is recommended that this case be closed as unfounded. We did review, this was all on BWC footage, there was no slamming, and we do concur with the finding of the Inspector General. The next case is 2025-0468. This was an allegation of misconduct. The complainant alleged that an officer was rude by being extremely dismissive and unprofessional. The evidence involved CAD, BWC, and review of policy and procedure. The DIG attempted on multiple occasions to obtain a statement from the complainant and her brother, but was unsuccessful. With regard to this allegation, the investigation found the officer did not behave dismissive or unprofessionally. He arrived, conducted his investigation, completed a report at the request of the complainant's brother, and therefore it is recommended that this be closed as unfounded. We reviewed it and we agree. Case number 2025-0473. This is an allegation of misconduct. The complainant alleges that the officers improperly entered his apartment. 2, the officers coerced and intimidated him to provide his identification. 3, the officers violated his right to remain silent. 4, the police report misrepresented his statements. And 5, the officers racially profiled him and were discriminatory against him because he is black. The investigation consisted of the email received from the complainant, the review of CAD, review of BWC, and a review of CPD policy and procedure. In regard to allegation 1, the investigation found no evidence to substantiate this allegation. The complainant invited the officers into his apartment. Therefore, it is recommended that this be closed as unfounded. With regard to number 2, the investigation found no evidence to substantiate this one. The officers asked for the complainant's identification to conduct their investigation. When the complainant stated he would not provide his identification, one of the officers advised him he could be arrested for not providing his identification. Therefore, it is recommended that this be closed as unfounded. Number 3, the investigation found no evidence to substantiate this allegation. At no point during being questioned by the officers did the complainant invoke his right to remain silent. Therefore, it is recommended that this allegation be closed as unfounded. Number 4, there is no evidence to substantiate this allegation. The report completed for this incident was accurate according to what was observed on the BWC. Therefore, it is recommended that this be closed as unfounded. Number 5, the investigation found no evidence to substantiate this allegation. The individual who called the police about what occurred identified the complainant as the suspect, and no discriminatory behavior was observed by the officers per BWC. Therefore, it is recommended that this be closed as unfounded. We reviewed the case and we concur with the findings of the Inspector General. I think
Board Member Younger, did you skip over a case?
I'm on the last case right now.
What about 0468?
0468. Let me look and see.
think this is the one where the attempts were made to,
Was that the
yeah, for the
administrative
brother.
closure?
It was
Closure?
unsuccessful.
Yeah, this was the unsuccessful.
Attempts, yeah.
Is that 0409?
0468?
0468.
I have administrative closure on 0409. Let me go back.
Zero 0409 is.
Yeah, that's administrative closure, 0409.
Well, 0409 is, let's see,
That's the one in the Mock Park incident.
there were 3 allegations, and number 1 would be administrative, number 2 is administrative, number 3 is administrative.
Yeah,
That's
0468 was
Zero-
an unfounded case.
0468 was, let's see, it was unfounded, right?
Yeah, the outcome was unfounded.
I read it. Do you want me to read it again?
No.
Okay. Thank you. I think I'm on my last case now. Okay. 2025 0551. This is an allegation of misconduct. In this case, an officer, let's see, the complainant alleged that the officer harassed him for no reason, and an officer detained him for no reason. The DIG's investigation consisted of CAD review, BWC footage, and review of CPD policies and procedures. With regard to allegation 1, the investigation found the complainant was witnessed hitting a sign in a parking lot. When the officer approached the complainant, he was still in the vehicle, had an open container, stated he had made a mistake, and admitted he had been drinking beer all day. The officer arrested the complainant for OVI, wrote the complainant a citation, towed his vehicle, and released him upon his own recognizance. There is no evidence the officer harassed the complainant. Therefore, it is recommended that this allegation be closed with a finding of unfounded. With regard to allegation number 2, the investigation found the complainant was witnessed hitting a sign in the parking lot. When the officer approached the complainant, he was still in the vehicle. This is the same thing. He was in the vehicle, said he made a mistake, admitted to drinking all day. The officer arrested him. The same facts as before. Therefore, it is recommended that this be closed as unfounded. So we did review the case, and our committee does concur with the findings of the Inspector General in this case.
There was also 2 witnesses.
Thank you for remembering younger. I can do it for you. All right.
Approve them all?
Well, I was just gonna, that's what we're getting ready to
Okay,
do.
we got it.
So on case 2024-1129, there's a finding of unfounded. 2025, and I'm just going to read these numbers. 0245, there was a finding of exonerated and exonerated. 0310, 0312, 0330, 0342, 0344, 0351, 0372, 0390, 0401, 0409, 0438, 0439, 0445, 0473, 0468, and 0551. Committee number 2 agrees with all of the findings of the Inspector General. All those in agreement, say aye.
All right.
Any opposed? Any abstentions? All right, thank you.
There were 2 DIG allegations.
We can sustain those.
I wrapped it all up
You
in.
Yeah,
did
let's
wrap
just-
it all up?
yeah.
Okay,
I wrapped
good.
it all up in.
That's
think so.
perfect.
Yeah, I wrapped
That's our,
it all
that's our
in.
new way to do it.
We're going to be a little bit more efficient today,
Yeah.
so I
That's
just wrapped
fine.
it all up.
That's perfect.
All right. Any good for the cause? There was one, did you want to talk about? Oh, you abstained? Okay. Well, that's that discussion. Any other comments, questions, or concerns?
You abstained?
No, for,
I'll retract mine.
Oh, okay, thanks.
Yeah.
Sorry.
Discussion. Well, one, I thought it was great to have the assistant chief in for that conversation about policy and practice for CPD. I think this section, in terms of the policy and process section, I think one of the aspects that brings up to board member Nathan's point, I know he's not here today, but I want to bring it back up, which is really how we structure, and I know Chair Burns is not here as well, but in terms of how we actually structure the meeting process, in terms of how we do these meetings. So I think it's great that we've now established set aside time for policy and process review. But I would propose, and this is a recommendation on the table for further discussion, is even getting back to how we are actually reading out the cases. I think often I've been blamed before in terms of the amount of questions that I have when cases come up, and we have long discussions, and some people have had issues with that and taken issue with that. Intentionally today, did not have any specific questions worth the cases that board member Younger went over. That still was a quite lengthy review process, and had committee one had our cases, we would be here for another hour and a half potentially. I think that the way in which we currently have our case review process structured, it's extraordinarily difficult to follow. If you're watching online, if you're a resident in the audience, it's kind of hard to follow and keep up with everything that we're saying. And I know that we are reading cases aloud, but I don't know if there's actually any sort of meaningful engagement. It's kind of hard to do so. One potential recommendation option to consider is just actually flagging cases for discussion. And so ahead of each board meeting, there might be an opportunity for board members to flag a particular case that they want to discuss, or residents that are either watching online or here in person to flag those cases for additional discussion. And the remainder of those cases that we've reviewed either individually as a committee or even as a board as a whole, that might be the opportunity for us to, move past those without even having to read the summary. And so I wanted to open that up for discussion. I know there have been some concerns in the past from folks of like, what happens if we don't read every single case? Are we not giving residents a full access to this? And so I'm trying to strike a balance here that could spend more time on what are the patterns, what are the themes that we're seeing come up among these cases. So I just wanted to open that up for discussion if folks had any thoughts there.
We've got till 5. Why don't we discuss patterns and procedures right now? We have time, so any patterns and procedures that you would like to discuss, let's do it.
Well, part of that discussion is, in terms of how we're structuring the way we read these cases.
As of right now, we didn't read committee number 1. If we had committee number 1 to read, we could have probably run through those in a half hour. I don't know that.
But what about my point that I don't think there's any serious, meaningful engagement in terms of just reading cases aloud?
I think we're giving citizens in Columbus, Ohio their due, and this is my personal opinion. I think everybody else should, flagging cases for discussion. And I'm thinking, all these cases, these 18 citizens who filed these complaints, who would I flag? What would I determine? I'm trying to figure out what would I flag?
I think there's some opportunities for meaningful engagement if folks want to have further discussion about a particular case. They can flag that for further discussion. For example, if I reviewed one of your cases ahead of time and said, okay, I had a question about this one in particular, that might be something for further discussion. Maybe not, but
Okay.
it would move past kind of, I think, what can become, not your reading, but just the reading as the board as a whole, just kind of a monotonous reading of cases over and over again.
Just think about that, though.
no-
Each committee member would have to read all the cases. We have enough time. I mean, I read 18 cases, and then I met with my committee, and we discussed them for several hours. And I'm hoping that Committee One trusts that we did this work. Just like because now for
I agree.
me to finish this, do everything else I do in my life, and then read your 19
You don't need
cases
to read.
would have been hard.
You,
I want to trust that you do your jobs and we do our jobs, and we give the citizens who wanted this, the 76% who wanted this civilian review board, what they voted for.
Of course. So part of that is voting for a board that is impactful and is focused on a number of these issues beyond just reading out cases. To say, look, we can read cases out loud. We've been able to do that, and I think we've done that exceptionally well. But in terms of what we're doing beyond that, which is we can still defer to other committees. If you don't want to read Committee One's cases, you don't have to. And so the deference is that we've reviewed it as a committee, we've discussed it as a committee, and we believe, like, we agree with the findings or we disagree with findings, and if so, we will read those cases in particular that we had concerns about. I'm not saying to never read cases out loud again. I'm saying if there are particular cases we've had concerns about, it makes sense to read those aloud. You don't have to necessarily read those cases.
I think Board Member Strickland, what would be helpful, and I know you've prepared documents in the past, perhaps for the October meeting, if you could outline a potential process that everybody can lay eyes on, that they can read it, digest it, think about it, and then we offer commentary at that meeting and discuss whether or not it's effective. Because I think what we're having to figure out is how to strike a balance between ensuring that there is basically due process with reading all the cases, and then making sure that there is also meaningful discussion. I think what Board Member Younger is getting caught up on is her committee already has read several cases. So it's very difficult to then flag which ones are more important that should be discussed in the meeting. Because that's essentially what it sounds like you're proposing, which is why I'm saying, could you perhaps lay it out and outline it for us then, so then we can better understand what you're trying to say.
Yeah, I'd be happy to. And I think part of what I'm suggesting is that we would flag it as an individual committee. Like, we would say, our committee wants to discuss this case further, because we had, disagreements or further comments there. So we're going to probably read aloud 3 of the 15 cases that were actually assigned this week. And if you wanted to, if a committee member wanted to go above and beyond and say, hey, look, I actually took a look at Committee 2's, I actually have some thoughts there, I just wanted to flag that ahead of time. I think that is like a perfectly reasonable approach. And I think the concern that I have is just the way that we're reading out cases. And unless they're done by theme or done by something, it's really hard for anybody to follow. Like, you're going to be talking about one thing on this day, and then you're going to be talking about an entirely new thing. And if you're just watching online, if you're a resident in the audience, it's kind of hard to follow unless it's maybe your case that you're hearing about.
I get what you're saying, and I think you make several valid points. I would also offer this. When we have the discussions, one of the things that has consistently happened in our meetings is somebody from another committee would identify an issue in a different committee's case that they would bring up and discuss. For example, Board Member Younger, she had a case today. I think it was 1129, right? And that case had a lot of stuff going on. It was with a juvenile that was struck by a police officer's car, and they agreed with the findings or the outcome of that, right? I believe that's what it was. One of the things that Board Member Younger mentioned was that the officer didn't turn on the body cam. And so somebody in our committee could have picked that up and said, well, wait a minute, this officer didn't turn on the body cam, however he has this situation, why wasn't another allegation sustained and brought upon by the DIG? So you see a different committee could have picked that up and raised that as an issue. So I think there is some benefit to having the cases read out loud, because there's things that perhaps our committee might pick up, committee one might pick up, that committee two didn't. And so again, that's why I'm saying, could you create an outline where we can perhaps try to strike a balance between this? Because I think if we can come up with something that's tangible and practical, we can definitely implement it. I'm always for trying to improve a process, but it's just doing something and improving the process in such a way that it still meets the needs that we are trying to accomplish.
Yeah, I'd be happy to. I think that that is a process point that, I'm happy to provide a kind of documentation for what that might look like. And I think we can also practice it as a committee. We could pilot out what this would look like if committee 2 and 3 wants to continue to read off cases. That's certainly something they can do. And then committee 1, depending on a conversation with board member Nathan, and obviously a vote among our.
I think that whatever process you put in place, just like Dr. Jones said, that we need to look at that and process that and kind of see what that looks like. I think that whatever one subcommittee is going to do, I think all subcommittees need to do. I think it needs to be consistent. But I think that whatever process you put in place, I look forward to seeing it and look and see what that looks like. But I think then at that point, then we look at it and see if that's something as a board that we all agree on moving to.
And that's something simple. I mean, if you propose something, you can send it ahead of the October meeting, then we can discuss it during the October meeting, or if you want to present it during that, we can carve out time in the agenda to go over it. But I think there's definitely opportunity to do so. Now, I know I think we're at the rec center, so we got reduced amount of time,
It's
so
even better.
we can
It's
we can make sure that we're efficient with it. But I really think. And I'd be more than happy to help you prior to
I'd
the
love
meeting.
to. I'd
We
love
can
that.
collaborate
Yeah,
on
let's
something
collaborate.
and come up with something and see if it's practical for everybody.
That's perfect.
We all good with that?
And I agree with what Dr. Jones just said, that, we should be hopefully all listening, and like with that one case, that he didn't have his body cam on. And as we listen to the other person as they're reading the cases, we should be listening to see if there's something that committee missed.
I
with the
agree.
bi-
I mean, certainly. I just think our process is kind of inefficient.
Okay,
And so, again, it has nothing to do with, anybody's inability to listen or not. I just
Yeah.
think in terms of how can we have more meaningful discussions and dialogue, and also feedback from community about our process and about the impact of the board and kind of the work that we're doing.
I think we can definitely do that.
Thank you.
Were you getting ready to say something?
Could I?
Yes,
Okay.
absolutely.
I guess I'm old school, but I think we have a responsibility to the citizens to read these cases out. If they don't have, and I see what you're saying, but if they don't have the narrative available to them online or someplace, I think they need to get a synopsis here read out to them, so.
100%. And I think part of the proposal would be including a synopsis. So this, I think, ties into this data dashboard that I keep repeating about over and over again, this public dashboard, which I know is a more intensive process than maybe initially thought out about, which is, look, if we have a public dashboard that's readily available for people to be able to see, any resident from this city and across the country can actually go and see what each case review looks like, including the narrative that has been implemented on that case review. I think that would be a tremendous opportunity and benefit, and would do well for the residents of Columbus to say that you can see. You don't have to dig through agenda, meeting minutes. Like, you can actually see directly on this dashboard the narratives of each case that we're reviewing every single meeting. And so I think that's kind of a opportunity to strike a balance. And I understand that takes some time in terms of actually implementing that dashboard. But I think there's some interim steps that we could play a role in. And if funding in capacity is a concern, that's something that I think city leadership, mayor's office, council, Department of Public Safety can continue to play a role in. Do you have thoughts there? On the dashboard? Do you have questions?
I'm going to forward the email that was shared with you regarding that. I don't know if they got the email.
Oh, I got, in terms of it's going to take time?
Yeah, I don't know if the whole board got it.
Oh,
so that
great.
They're made aware that.
Yes, so-
Yeah, there's been,
I would appreciate
Yeah, so what's being forwarded to the board is that in conversation with the Department Inspector General, the dashboard process, been convening all the different folks in Department of Technology, that it's a much more involved process than initially kind of set out to be, and so it's going to take much more time. It's a longer-term project. My interim solution, I think, is in the interim, instead of this massive public-facing dashboard that is on the web, a website and a super fancy design, is really thinking about how can we, in an interim basis, maybe pilot out. This is what it looks like the past 10 cases that we had last month or a couple months back, and this is what that dashboard could look like at a pilot level. And so the idea is that every resident, even if you don't read their cases out loud, will be able to see those case narratives and full case reports, actually.
All right, so it looks like we have were you going to say something?
Just one more thing. So when you prepare this presentation, will you also prepare what this dashboard will look like if we stop reading the cases aloud, that will allow the citizens to be able to go to your dashboard to get their information?
It's not my dashboard. City's dashboard.
Let me just clarify.
Yeah.
We're talking about two different
Yep.
things here. A process review or enhancement, I guess you could say, changing the process for which we review cases here. The public-facing dashboard is something that's a much longer-term process. So that's not something that can be implemented right now. So I think right now it's just focusing on what the review process looks like in our existing meetings that we have. If there's a way to enhance it, we're going to explore that and see. And Board Member Strickland is, I guess, going to work with me to put together a potential outline of what that could be, provide it to the board, so then during the October meeting, we can have a discussion about whether or not that is feasible. So
Yeah.
that's the plan moving forward, because we've been having this conversation for the last several meetings, and it just seems to be going in circles. And I don't like to do things in circles. I like to have tangible outcomes. So I think if we put something together concrete for people to look at, then I think that'll be helpful to move this thing forward.
Yeah, I agree. And I also think it's separate, but it is connected, I think, to some of your concerns, which is that if we're not reading it out loud, how else are residents going to be able to access the cases? I mean, I think a traditional answer is the meeting minutes, but in terms of, to your concern, Dr. Ford's concerns, is Board Member Jackson's concerns, is also understanding, well, if you can't read it out loud, how else are we going to do that? And so I also understand this proposal that Dr. Jones and I are going to work on can't necessarily be implemented right away without all these other solutions, right? And
Correct.
so I think one of the ideas is that in the interim period, finding an alternative while we're working on this longer term project of making sure that folks and residents have access to cases readily available to them. And we can work on that. So if you have input on what you'd like to see that looking like, would love to have that conversation.
All right. So we got a plan for moving forward. Case assignments, they are listed in the agenda for today, and Stephanie will send those out to us also at a later time. In terms of our next meeting, it will be October the 7th. That is a Tuesday at Barnett Community Recreation Center. That is from 4:30 to 6:30. Is that correct? All right, so that is a abbreviated meeting, so we'll be very efficient there. That covers everything. Do I have a motion to adjourn?
I'll make a motion.
A second? We have a second? So moved. Thank you all.